Welcome to today's program titled A Global Perspective on DEI Identification. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE attendance verification code. Please write this code down, as it will not be reread, and it is required on the CLE credit request form. During the program, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP, for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Caitlin Lane. Caitlin, please go ahead.
Thank you, and good afternoon, and thanks everyone for joining. My name's Caitlin Lane, and I'm a partner in Seyfarth's International Employment Law Group, and I'm based in New York. And I'm joined by my colleague, Catherine Weaver, a partner in the International Employment Law team based in Hong Kong. On the next slide, we'll take a look at the agenda for today. And what we plan to discuss are a few main topics. We're going to discuss DEI identification from a global perspective with a focus on considerations for global organizations, APAC and EMEA approaches to DEI monitoring, and we'll round it out with best practices. Let's go to the next slide and start with considerations for global organizations. So when global organizations consider employee data collection and analysis as part of their DEI plans, it's really critical to consider the local, country, and regional laws that dictate what data can be collected, how it can be collected, and how it can be used. So I think one important starting point is that a one-size-fits-all approach may not be feasible, and this is especially true if the data collection really becomes more granular or is mandated in certain instances. Global employers should also be aware that there are often different rules that apply to applicants versus employees. Today, we're just going to be focusing on employee data collection, but we raise this point because it's really important for companies to bear it in mind as they're assessing DEI initiatives and the intersection of data collection. Generally, the rules are a bit more prescriptive for applicants, meaning that less DEI information can typically be collected for applicants as opposed to employees. So that's really a watch out area. What companies can collect can also be impacted by mandatory reporting obligations. So for instance, in certain jurisdictions, pay equity and transparency legislation requires reporting on certain pay and gender metrics. So again, something to think about from a global perspective. And finally, when employers think about DEI collections globally, it's critical to consider company objectives to ensure that the metrics and the data being collected are actually able to achieve the intended goal. And this is, I think, a theme that you'll see throughout our discussion today. So really thinking about what are we trying to achieve at the forefront can help shape the plan for DEI identification data, what you want to do and where you want to go. With that, I'll hand it over to Kat to introduce herself and give an overview from the APAC perspective.
Thanks, Caitlin. So by way of introduction, I'm Kat Weaver. I'm an employment law partner in Seyfarth's international practice. I co-manage the Hong Kong office, although this week I'm in San Francisco and it's very cold. You can probably tell that I'm British. I spent the first decade of my career in London practicing UK employment law and running EMEA-wide employment projects, and then I moved out to Hong Kong 7 years ago, qualified there, and I've been running Asia Pacific employment projects as well as practicing domestic law. I cover all aspects of employment law, but I do have a particular interest in DEI, and I spend a fair bit of time advising on it. I run things like DEI audits for clients in the region, I review their policies, I hold meetings with their stakeholders, conduct training, and of course help them devise their DEI employment and monitoring surveys. So the topic of today's webinar is one I'm very happy to discuss. Caitlin and I are going to explore 5 key themes related to DEI monitoring during this webinar, and I'm going to cover the Asia Pacific approach and Caitlin will cover EMEA. But before we get into the meat of the topic, I wanted to give you a brief-ish overview of the general approach to DEI in Asia Pacific, as I think it will be quite a useful reference point for the rest of the webinar. So the way in which DEI projects come to me in Asia Pacific is often as part of a global project initiated by a company's headquarters, usually in Europe or in the US. And often the client's head of HR or the in-house employment council in Asia is asked to roll out this DEI policy or the monitoring project. And the expectation is that it's going to be relatively simple and no or very few changes to the headquarters template materials will need to be made. Now, unfortunately, that's not quite how it works in Asia Pacific. So each jurisdiction in the region comes with its own set of particular DEI laws and guidelines, and of course its own cultural sensitivities and societal attitudes towards DEI topics. And that means that rolling out anything of a DEI nature in Asia Pacific has to be handled with care. There are a few things companies should be aware of when introducing DEI initiatives, including DEI monitoring in Asia Pacific. The first is, with a few exceptions, DEI is a relatively new concept in Asia Pacific. Anti-discrimination and harassment laws are not as developed as they are in other regions, and discrimination lawsuits are just not as common either, and there's various reasons for that. Second point is that there are fewer quotas and reporting obligations around DEI data in Asia Pacific. Therefore, DEI monitoring is not considered to be as necessary. Third point, a lot of Asia Pacific is quite conservative and not particularly comfortable talking about DEI matters, and certainly not comfortable answering questions about DEI attributes in surveys. And all of that makes for it being more challenging to introduce and roll out DEI initiatives and monitoring in Asia Pacific as compared to, say, the UK or the US. That said, things are starting to change in the region. Countries are starting to pay far more attention to DEI matters, and they're introducing new laws to enhance protection and to improve equality. I'm going to give you a few examples of things that have been happening recently. So Singapore is due to introduce workplace fairness legislation later this year, although my suspicion it's going to be pushed into early next year. And this legislation will, for the first time, expressly prohibit discrimination against applicants and employees in the workplace on the grounds of nationality, age, sex, marital status, pregnancy status, caregiving responsibilities, race, religion, language, disability, and mental health conditions. So that's quite a sea change for Singapore. Now, Hong Kong, not to be outdone by Singapore, has introduced a new rule as well, a rule for all listed companies on the Hong Kong Stock Exchange, that by the end of this year, all boards must have at least one female director on them. And so far, my little birdies have been telling me that around 70% of the listed companies have complied, which means there's still a bit of a way to go, but we also still have a few months left in the year. Australia passed legislation last year requiring firms with 100 or more employees to publish their gender pay gap data from 2024 onwards. And similarly, Japan brought in legislation in 2022 that required companies with more than 300 employees to publish their gender pay gap data annually within 3 months of the end of the fiscal year. So this whole new focus on DEI is driven in part, I think, by the war on talent in the region. And I know that war on talent is global, but we're feeling it particularly in Asia Pacific. And there's also a creeping increase of activism in the workplace too, which I think may be having an impact. And also companies are seeing the financial benefits of increased diversity. And so we're getting more buy-in from the C-suite in relation to DEI initiatives. Now, given that Asia Pacific is still kind of at the early stage of its DEI journey, most of the monitoring, in my experience, focuses on some very simple data points, so gender and race. They seem to be the ones that Asia Pacific are the most comfortable with. Monitoring attributes outside of gender and race is less common, usually because it seems to be either unnecessary or too difficult or controversial. And that's not to say it's not happening. It does happen, but it's normally coming from international companies that are rolling out DEI monitoring across all of their jurisdictions and asking similar questions in each jurisdiction. So that was my general overview of Asia Pacific DEI approach. And I know that Caitlin's going to be adding in her comments on the EMEA aspects of things as we go through our 5 key topics on DEI monitoring. And the first topic is on the screen now, so we'll keep that slide there. The first topic is on the question of what data can be collected in a DEI survey. So in order to answer that question, we must first ask, what are we trying to achieve through the DEI monitoring? What's its purpose? Is it that we've got an internal DEI goal of recruiting, say, 50% more women into senior leadership roles? Or do we need to comply with a government mandate to recruit X amount of disabled employees? Or are we at the beginning of our DEI planning process and we simply want to understand the diversity composition of our current workforce in order to then consider what kind of DEI strategies, goals and policies we want to put in place? We need to be clear on what our purpose is and what the data is that we need to achieve that purpose. And this is important in many reasons. In Asia Pacific, as per many other countries, the data privacy laws are clear that you should only collect personal data for legitimate purposes and should not collect any more data than is necessary. So speaking of data privacy laws, these should obviously be checked in each jurisdiction to ensure that your DEI monitoring project complies with them, or at least that you manage risk around this. But if that sounds like too much time consuming and too expensive to deal with, then thought should be given at the outset of the project on how to potentially avoid triggering data privacy legislation. For example, could you do the whole of your DEI monitoring on an anonymous basis? And we'll talk about that in a bit more detail later on. In addition to data privacy laws, you need to also be thinking about discrimination laws in the jurisdictions in which you want to roll out this DEI monitoring. You want to be thinking about, are there any questions that you are prohibited from asking? Does positive discrimination exist and is it permitted in that jurisdiction? What attributes are protected in that jurisdiction? And when it comes to protected attributes, these differ widely across Asia Pacific, with some jurisdictions like Taiwan, for example, having a very long list of attributes that are protected, and other jurisdictions like Japan having a very short list. Now, one of the reasons for checking the protected attributes is if an employee has been asked questions in a survey about something that's related to a protected attribute, and then something bad happens to them at work, they don't get promoted, they don't get a bonus, they get made redundant, then they might try and mount a discrimination complaint or claim against the company as a result, trying to link the two things. But if you know that in a particular jurisdiction, say in Hong Kong, you know that age is not protected, you know that sexual orientation is not protected, but you know in Vietnam that things like religion, opinion and skin color are protected, then you will then be able to manage your risks around what questions you're going to be asking in your DEI monitoring survey and what you're going to do with the results accordingly. So it's good to have that information as to what's protected and what's not, in order to manage your risks and of the claims that may potentially come up. Cultural sensitivities are a huge consideration in Asia Pacific. I've already mentioned that the majority of Asia Pacific is quite conservative, in particular around such topics as LGBTQ rights, gender identity, transgender rights, and mental health conditions. By way of example, the only countries or jurisdictions in Asia Pacific that recognise same-sex marriage currently are Australia, New Zealand, and Taiwan, with Thailand hot on its heels, hopefully. That should be coming in hopefully soon. And then Singapore, for example, only recently in 2022 legalized gay sex. So while it may not be illegal to ask certain questions in a DEI survey in Asia Pacific, it will often be considered inappropriate or culturally insensitive, and employees may be concerned about how that data will be used. Even if you tell them it's anonymized and it won't be used in any way that's nefarious, they still might be concerned about it. Another thing to think about is your drop-down choices for your DEI questions. So, for race, for example, what kind of categories should you list there? Will you change those categories depending on the country in which you are asking the DEI survey questions? Now, what I normally do is look at a country's census to see how the government is categorizing race, and then use that, and that's a good indication of the kind of drop-down categories you should have in your survey. For gender, many jurisdictions in Asia Pacific are lagging behind on transgender rights. So asking someone to specify their gender identity could be considered to be controversial. And having a long drop-down list of all the varieties there could also be seen as controversial in some jurisdictions. From a data privacy perspective, the data provided by applicants and employees in a DEI survey would constitute personal data under local laws unless it's anonymized, and its collection, transfer, use, storage, etc. would need to comply with local data privacy laws. Companies should be aware that in some jurisdictions there's a distinction between personal data and sensitive personal data, and the way in which you process that sensitive personal data is sometimes quite different and far more stringent, the rules around what to do with it. For example, in Hong Kong and Singapore, there's no separate definition for sensitive personal data, but China, Taiwan do define sensitive personal data. Taking China, for example, processing sensitive personal data can only be done for very specific purposes and under strict protection. And when it is collected and processed, then additional notifications stating the necessity of the processing and the impact on an individual's rights and interests would generally be required to be provided. So that's enough from me. Caitlin, I know that some of the jurisdictions in EMEA also distinguish between personal data and sensitive personal data. Can you share a bit more on that, and also just generally on what data can be collected in EMEA?
Thanks, Kat. Yeah, absolutely. So, a lot of the principles that you've just discussed are actually similar in EMEA, and that's particularly true when it comes to discrimination risk. Most jurisdictions in Europe in particular, within the region, have various protected characteristics, perhaps even more so than in APAC. And so when collecting data, employers really need to be mindful about how that data is going to be used and ensure that there's not, of course, any actual discriminatory use, but as well as kind of looking at the optics and making sure it does not appear that there's any sort of discriminatory motivations or uses that could arise. Now, Kat, you touched on personal versus sensitive personal data, and this is actually really a critical point of importance in EMEA, particularly in the EU member states, and that's due to the General Data Protection Regulation, commonly referred to as GDPR. The GDPR includes various categories of sensitive personal data that essentially employers are prohibited from collecting. That's really kind of the starting point, unless there are either is valid consent or there's a valid legitimate interest in the employer. And we'll discuss those two concepts in a bit more detail later in the program. But the takeaway here is that collecting sensitive personal data in particular is generally difficult to justify. In some EMEA jurisdictions, employers, however, may be able to collect certain data points because they have to comply with certain laws. So, for example, some countries, including Italy and Romania, have disability quotas. Essentially, the employer has to have a certain percentage of the workforce be made up of individual with a certain level of disability, which is typically determined by the government. And so in order to comply with that obligation, the employer actually has to collect this data, subject, of course, to data privacy regulations and requirements. So, we tend to focus when we talk about EMEA, we tend to automatically think about GDPR, but of course, there's other countries in the region that are not covered by GDPR. And so there are still local data privacy requirements that have to be taken into consideration. And so you kind of mentioned this before, but it's a point worth reiterating because I think it really spans the globe. It's really important to assess the local position in any jurisdiction that a company is planning to collect employee data in, because it's always going to have some local variation. There can be nuances in terms of what can actually be collected and the means to actually collect it. And those will vary between countries, even within a region. So, discussing means of collecting data, Kat, maybe you can tell us a little bit about consent requirements in APAC. I think you're muted, Kat. Can't hear you. Let's see.
Hello, can you hear me?
Now we've got you.
Apologies for that. As I said, I'm in the San Francisco office and tech is letting me down. Right, in terms of consent, so whether consent is required to collect DEI data depends on the jurisdiction and whether data is sensitive or not. So let's take Hong Kong and Singapore as an example. You generally do not need to seek consent from data subjects as long as you comply with data privacy laws and you notify the data subject in advance of what the purpose of the data collection is, whether it's going to be transferred to third parties or overseas, how it's going to be stored, how you can amend it, etc. There is an exception to that in Hong Kong, which is that if personal data is collected for one purpose and then the company wants to use that data later for a different purpose, then you need to go out and seek consent from the data subjects to do that. Looking at other jurisdictions, Japan only requires data subject consent when collecting and using sensitive personal data. And as mentioned before, express consent is needed in China for the collection and use of sensitive personal data. In Korea and India, consent is generally required. So it's important to understand the rules on consent in the jurisdictions you want to conduct your DEI monitoring in, because they differ quite widely across Asia Pacific. And as such, you might decide that you're only going to request DEI data on a voluntary basis in some jurisdictions or on a completely anonymous basis in some or all jurisdictions. Caitlin, I know the rules around consent are quite different in the EU, aren't they?
That's right. So in EMEA, it really depends on the country. So in those EU countries within EMEA, the preferred approach is actually to tie data collection to furthering legitimate interests of the employer. So as we discussed previously, under the GDPR, valid consent or legitimate interests of the employer are two ways to be able to collect data. And while employee consent is a possible avenue, consent tends to be heavily scrutinized and is easily viewed as invalid because of the notion that consent by an employee really actually in practice can rarely freely be given due to the imbalance of power between employers and employees. So when there is a genuine legitimate interest of the employer that can be tied to data collection, this is really the preferable approach, and it tends to be much more defensible. That said, it can be difficult to rationalize a legitimate interest to collect certain sensitive personal data, even when we do take DEI initiatives into consideration. And so, a proper analysis really needs to be undertaken, and there needs to be a true, valid, and legitimate interest that is being furthered when collecting this type of information. Of course, in non-EU, non-GDPR countries, consent is more frequently required and relied upon, and this is particularly true in Middle East countries in the region. So given the potential difficulties in obtaining consent or justifying collection with a legitimate interest of the employer, global organizations should really consider their approach and whether they make the data disclosure voluntary or mandatory. And so that's one way that we can look at it in a different lens to perhaps try and get more information than we would otherwise be able to get if we're really truly relying on those justifications. When we talk about voluntary and mandatory disclosures, Kat, what's the position in APAC?
Well, a lot of DEI surveys are carried out on a voluntary basis in Asia Pacific because there are limited laws on reporting DEI data and on meeting quotas, as I said at the beginning. So there's limited reason for employers to justify saying that employees' participation has to be mandatory, because there's no real laws backing that up. In some jurisdictions, so Hong Kong being an example, if you state that providing personal data is mandatory, you then have to explain the consequences of not providing the data. And that can be quite easy to do if you're dealing with something like health insurance. So if you're asking an employee or an applicant to provide personal data details so that you can set them up on the group health insurance, and you say to them, well, if you don't provide that, then obviously you're not going to get the health insurance. So you're explaining that this is mandatory, and the consequence of you not providing it is you don't get signed up to health insurance. When it comes to completing a DEI survey, then it's more complicated to try and think of the justification, the consequences for not doing so. But if there are laws in place that require you to meet a quota or report on your statistics in an annual report, for example, then making the disclosure of personal data mandatory would be more justified. But then you should think in that situation, do you need the employees to be identified, or is it enough that you have that data from a statistical standpoint? So would it be fine just to have anonymized data? Before we get onto anonymized data, does the position differ much in EMEA on that regard in relation to voluntary and mandatory disclosure, Caitlin?
It doesn't. The position in EMEA is actually quite similar, especially when we think about mandatory laws. Yes, those are going to exist. We spoke about that a bit previously, but generally getting the information voluntarily is going to be a lot easier, and often will help with the breadth of the information that can be gathered. And so part of planning a data collection strategy for DEI initiatives should really include thought on that approach. So if employees are given a free choice as to whether they want to voluntarily disclose personal information, the range of what can be collected is actually likely to be broader and more inclusive. And, as an example, if employees are given the choice to disclose their preferred pronouns, they can opt out, they can not answer, but those who do want to respond, this information can help further DEI initiatives in a way that really doesn't impose on the data privacy laws we've discussed in a problematic way. At the same time, again, a one-size-fits-all approach may not be appropriate. So using the same example of asking for voluntary disclosure of preferred pronouns, asking that question in certain countries, for instance, some countries in the Middle East, would likely be viewed unfavorably and culturally insensitive. So even if it doesn't trigger a data privacy risk, there are certain questions that may not be culturally appropriate in all jurisdictions. And so that's something that has to be taken into consideration in the plan as well. So the issue of voluntary versus mandatory disclosure and what can be collected should also be considered from the perspective of whether it's going to be disclosed in a self-identifying way or an anonymous way. Kat, what's the position on self versus anonymous disclosure in APAC?
Well, the main point is that with anonymized data, then it's less risky, of course. There'll be less risk from a data privacy and a discrimination claim standpoint. If you can't identify the individual from the data, it usually doesn't constitute personal data, and therefore the data privacy laws will not be applicable. Also, if the data is provided anonymously, it'd be difficult for an employee to later say that they've been discriminated against because they disclosed that they had a protected attribute. Another quirk that I'll raise quickly here around Asia Pacific is in relation to Japan. So in 2022, it brought in a new category of personal data called pseudonymized. It's quite hard to say that, pseudonymized information. And that's where a data subject's personal details are removed from the data set and replaced with something like a code. So whoever's looking at the DEI survey results will not know who the individuals are, but there will be that information in the background that you could then link it back to. Now, the law said that if you only hold onto the pseudonymized data, then and you don't have that additional information in the background, then you only have to follow some very limited rules under their data protection laws. But if you still hold on to that additional identifying information, then even the pseudonymized information will be treated as personal data still, but you can, under the new law, use that data for additional purposes than the original purpose. So while anonymized data is less risky, self-disclosure of personal data can be quite useful for employers and employees. It can help with employers providing accommodations and support around disability, for example, and with DEI initiatives around setting up employee. Quite similar in EMEA?
It is. And in fact, particularly in EU countries, anonymized data may be the only way an employer can get certain data points. And so this goes back to the concept of what are we really trying to achieve with data collection and how does it help further the DEI initiatives? And so depending on those objectives, anonymous data might actually be a great approach and can allow for a broader range of information to be collected and can be quite sufficient for what a company is trying to do in the DEI space in particular. I know we're short on time, so I'm going to quick jump to the next slide and quickly touch on transfer and storage of data, which actually is quite aligned between APAC and EMEA. And so as you can see on the slide, cross-border transfer of personal and sensitive personal data is typically subject to very stringent requirements, particularly where the data is going to a country with less data protections. Many of you may have seen that is often the case in the US, that there's difficulties that we run into in dealing with the fact that the US is not necessarily considered as strong. And in terms of storing personal and sensitive personal data, the positions generally that data can't be stored for any longer than necessary to achieve its intended purpose for collection. With that, I'll hand it back to Kat to wrap up and run through a couple best practices.
Just checking that my mic works.
Yes.
Yes, good. Okay, so just a quick reminder on best practice. I'm going to rattle through this. Be clear about the purpose of your DEI survey before you start writing the questions and devising the drop-down options. Understanding how the data will be used will help you then inform how the data is collected. Don't ask unnecessary questions. Make sure you tailor your requests to match the objectives for the data use. Do your homework on data privacy requirements in the jurisdictions you intend to roll out the survey in. The laws differ significantly in many ways. Don't underestimate the importance of cultural norms and sensitivities. While the law is important and should obviously be followed, also consider whether questions are appropriate for each jurisdiction you're rolling it out in. Remember, one size does not fit all when it comes to DEI monitoring. Last 2 points, consider anonymizing your personal data in order to reduce data privacy and discrimination risks. And also don't forget that there are strict rules around transfer and storage of personal data, and make sure you factor that into your project planning. So we'll flick on to the next slide, which is the CLE code. And I've been told I need to read out the code to you, which is SS7341. And you should also be able to scan it. And remember, it was sent to you in an email as well earlier today. Apologies that we didn't get time for the questions. I have seen a number of them come through, so we'll aim to try and get back to you on those. But if you do have additional questions, then please feel free to email us. Thank you.